I could talk all night giving examples of growing disregard for religious freedom and the many threats to free exercise in our nation today. I won't do that because I want to leave time to discuss the positive case for religious freedom on legal, constitutional, and moral grounds. But before I move on to that, no summary of the dangers to religious liberty currently facing our nation would be anywhere near complete without mentioning how the gay marriage movement and the gay rights movement more generally also brings with it a whole host of grave threats to religious freedom. Many people are aware of the fact that Catholic adoption agencies and the states that have legalized same-sex marriage or same-sex unions have been shut down because now their unwillingness to place children with same-sex couples is considered illegal discrimination, despite the growing body of social science research which clearly shows that children do better with a mom and a dad. But that's just the tip of the iceberg. Christian church photographers, for example, have been sued and lost when they refused to photograph a gay wedding. Likewise, churches have been sued and lost for refusing to rent out their church halls for a gay commitment ceremony. In California, a U.S. district court held that a student's religious speech against homosexual acts could be banned by his school as injurious remarks that intrude upon the work of the schools or on the rights of the other students. And in Massachusetts, the Court of Appeals ruled that a public school may teach children that homosexual relations are morally good, even in spite of the objections of parents who disagree. The same has occurred with mandatory sex ed regulations in New York City, which clearly have, among other things, the normalization of homosexuality as one of their aims, as well as mandatory anti-bullying campaigns in schools throughout the country, and the recent California law requiring all schools to teach gay history, again, with no real parental opt-out. Basically, the gay marriage movement wants to make gay the new black, to make orientation exactly the same as race, as the California Supreme Court explicitly declared. And since equality, especially racial equality, tends to trump religious liberty in our constitutional scheme, that's very bad news for religious freedom. Indeed, just a few weeks after declaring that same-sex marriage is a constitutional right, because, as the court says, wants to claim sexual orientation is a protected class just like race, the California Supreme Court explicitly affirmed that the government has the right and the obligation to punish a Christian doctor who refused to perform an artificial insemination procedure on a lesbian couple. Treating two women in a union any differently than a husband and a wife is now the same in the eyes of the law as discriminating on the basis of race. And it's a well-established principle of law that religious beliefs do not give an individual or an institution a right to violate norms of racial equality. So those with principled opposition to same-sex marriage may also find themselves unable to get state licenses to work, for example, as physicians, social workers, marriage counselors, psychologists, attorneys, and teachers. In other words, the freedom to participate fully in civic life, conscientiously, on one's own terms, as a religious person professing one's beliefs, can be jeopardized by this new dispensation. In England, for instance, they're a few years ahead of us on this, so they can give us a sense of where these things are going. A Christian couple was denied the ability to act as short-term foster parents because when they went to the adoption agency or the foster care agency, they were asked what they would do if the 5-year-old they were going to foster turned out to be homosexual. They replied that they're opposed to homosexuality as a matter of principle, but that they would of course love the child because their beliefs teach them to love everybody. The state ruled that their prejudice made them unfit to be foster parents. And when the couple fought the decision, the judge said that the state must protect vulnerable children from being infected, and yes, they used that word, infected, by Judeo-Christian values on sexual morality. In the UK, all of these problems began with human rights and equality and anti-discrimination legislation, starting back in 1998. Those who said then that these laws were going to lead to religious freedom violations were laughed at. Now, in the UK, when a 69-year-old street preacher stands peacefully holding a banner that says, "Stop homosexuality, turn to Jesus," and a crowd of 30 young people assault him, the police arrest the 69-year-old, not the 30 people assaulting him, and they convict the 69-year-old of a hate crime, while his assailants get off scot-free. So we also need to be very wary of attempts to pass such laws in the US. Right now, actually, two are being pushed in Congress. The Employment Non-Discrimination Act, which usually goes by the acronyms ENDA, would raise sexual orientation to a protected status like race for the purposes of employment non-discrimination laws. Many schools, universities, daycares, shelters, and so on would not be exempted from this. Similarly, the Student Non-Discrimination Act, which some people call the Homosexual Classrooms Act, would make harassment on the basis of sexual orientation illegal in schools. And harassment would of course be read to include any speech expressing a negative moral judgment about homosexual acts. Of course, it sounds terrible to be against a non-discrimination law. It's terribly wrong, and any Christian should be deeply opposed to treating people unjustly, harassing them or bullying them, just because they experience same-sex attractions. But what these so-called non-discrimination laws want to do is make it illegal to express disapproval of the gay lifestyle, which is another matter entirely. Well, I think I've said enough to show that the threats to religious freedom in this country are indeed real and serious, and will get worse unless we make a concerted effort to stop them. But now I'm going to switch gears and explain the basis of religious freedom, both legally and morally. So first, understanding the legal and constitutional basis of religious freedom as a civil right in our country. So religious freedom and the protection of conscience rights more generally has been a core value in our nation's history since even before the official founding of the United States. Many of America's first European settlers came here in search of religious freedom. Some of the first experiments in genuine religious toleration happened in the American colonies, and freedom of religion, together with freedom of conscience, was a central concern of America's founding fathers. Thomas Jefferson, for example, declared that no provision in our Constitution ought to be dearer to man than that which protects the rights of conscience against the enterprises of the civil authority. George Washington himself likewise stated that the conscientious scruples of all men should be treated with great delicacy and tenderness, and it is my wish and desire that the laws may always be extensively accommodated to them. And James Madison, a key defender of religious freedom and the author of the First Amendment, said, "Conscience is the most sacred of all property." That right to freedom of conscience, is enshrined in our Constitution within the First Amendment, which reads, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." Note, by the way, that the Constitution says nothing about the separation of church and state. Indeed, at the time of the founding, many states had established churches, and the first half of the First Amendment, the prohibition on laws respecting an establishment of religion, is actually best understood historically as forbidding the federal government. The Bill of Rights applied at that time only to the federal government. That clause, forbidding the government from respecting an establishment of religion, is best understood as forbidding the federal government from tampering with any state laws regarding their religious establishments. Now, of course, as we know, the Establishment Clause is often read in a way that would make any public reference to God or religion illegal, as we've seen in so many cases trying to get "under God" struck from the Pledge of Allegiance, for example. And even want to make it illegal to accommodate religious organizations providing important social services, as we've seen also with the case of Catholic Migration and Refugee Services being denied their contract. But that is far from the original meaning of the clause. Nonetheless, there are still good and important aspects of Establishment Clause jurisprudence. A recent example is the Hosanna Tabor case, in which the Supreme Court upheld what's called the ministerial exemption, which allows religious organizations to hire the ministers that they want without having to worry about federal anti-discrimination laws. The government ought to stay out of the internal affairs of religious organizations. They shouldn't, for example, have any say in who gets to be made bishop or who is appointed pastor of the local church. That's one interpretation of the Establishment Clause that is good and valid, and that helps to safeguard religious freedom. The HHS mandate, in fact, runs afoul of the Establishment Clause because it tells religious organizations how to carry out their ministry, and also because the extremely narrow religious exemption treats some religious organizations as more religious than others. In other words, the government gets in there and tells religious organizations what they have to do and what their purpose has to be in order to count as sufficiently religious for the exemption. The other aspect of the First Amendment's protection for religious liberty is what's called the Free Exercise Clause. That's the clause, the part that says that Congress shall make no law prohibiting the free exercise of religion. This means that it's unconstitutional for the government to make it illegal for you to practice your faith unless there's an extremely good reason. Unless, say, your faith requires you to engage in human sacrifice or terrorism. This right has generally been understood to protect freedom of conscience more broadly, even when unconnected to a specific organized religion. The HHS mandate, and many of the other affronts to religious liberty that I've mentioned, clearly run afoul of the First Amendment in this regard as well. There's a lot more to be said, of course, about the way this clause has been interpreted in recent jurisprudence and what the reigning legal precedents are. But I don't want to get bogged down in technical details right now. I'm happy to talk more about that in the Q&A if people are interested. So the First Amendment is an important protection for our religious freedom, but it's not the only protection in our law. There's also a protection within federal statutory law under what's called the Religious Freedom Restoration Act, which was passed in 1993 by a bipartisan majority and signed into law by President Clinton. That law provides additional legal support for religious freedom. It was passed in the wake of an unpopular Supreme Court decision, Employment Division v. Smith, in which the court failed to grant an exemption from Oregon drug laws to members of the Native American Church who used peyote, a hallucinogenic drug, in strictly controlled sacramental contexts. What the law states, what the Religious Freedom Restoration Act states, is that the government can only burden religious exercise when a compelling state interest is involved and when the policy is the least restrictive means for achieving that interest. This law currently applies only to the federal government, although many states also have their own Religious Freedom Restoration Acts that they've enacted on their own. At any rate, the law does apply to the HHS mandate, which is an action of the federal government, and the mandate clearly fails to meet the test of a compelling state interest and the least restrictive means to achieve that interest. The mandate is uncontroversially a burden on religion. It involves a $2,000 per employee fine per year for failing to comply, which for Catholic Charities, which has about 70,000 employees throughout the nation, would mean, I don't know, do the math, a lot of money, right? And even if you buy the claim that the interest at stake is compelling, which many people don't, but which according to current jurisprudence would probably pass muster, still the means chosen are clearly not the least burdensome available. The government could easily give women free access to contraceptives without conscripting religious employers into doing it for them. It could do so directly through, say, Title X, Title X provisions and so on that already do this for free for lots of people on Medicare, for example. So anyway, that's a quick sketch of the legal and historical basis for religious freedom in our country. As I mentioned, there's much more to say here, so if you're interested, we can also talk more about this in the Q&A. Before we finish, I think it's also important to talk briefly about why, at a deeper level, as a matter of moral principle, religious freedom is so important. Why, even if the government didn't actually protect it in the Constitution and in the laws, it ought to do so. Why any just society ought to have, as a priority, the protection of religious freedom and the protection of conscience rights.